Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer, and this is the fifth, I hope of 5, videos in this series entitled Don't Do It! And what we're talking about is don't deliver as the buyer's broker a copy of buyer's inspection report or any portion of buyer's inspection report unless you first have seller's consent. And we have covered a ton of information in the first 4 videos, leaving us in this video to cover the final topic that I want to address, which is what I am seeing in the industry as listing brokers way overreacting when they get some, what they would describe, portion of buyer's inspector report. So I'm joined once again by my friend Ken Sachs.
Hello folks, Ken Sachs, Managing Broker, Professional Realty Services International. So happy to be here.
And Ken just, before the tape rolled, drew a, I think, really important similarity between where we were and where we are. You want to share it?
Sure. In the last video when Annie was talking about the 35R and sending the portion of the report or the report itself, I was sitting here thinking, this all started, talk about history, with buyer brokers weaponizing the inspection report. I'm going to use it to back the corner up into a seller, manipulate them, and get what we want.
Or back the seller into a corner.
Or just back them into a corner.
You're right. Okay. So
beyond the scope of what it's for.
Right. And I agree with you. And I love the phrase weaponizing the earnest money or weaponizing the inspection report.
Yes.
You weaponize the inspection report. And so now what we're seeing with this prohibition on buyers delivering any portion of the inspection report, we're seeing a complete reversal of fortunes, and we are seeing a weaponization of
the new language prohibiting buyer from providing the report or portions of.
For the benefit of the seller. And here's what that looks like. In fact, I'm going to give you the hotline Q&A that ignited this whole debate 2 weeks ago. In the Q&A that we published, I had used an example from the Spokane debate that we referred to in the last video. The example was this. The side yard, buyer broker writes on the Form 35R, side yard sewer line has collapsed. Seller shall replace the side yard sewer line. And the question was, has buyer broker waived buyer's inspection contingency by saying side yard sewer line has collapsed since that language came out of buyer's inspection report? And I concluded in my question and answer, no, buyer broker hasn't waived the buyer's inspection contingency by saying the side yard sewer line has collapsed, seller shall replace the side yard sewer line, because although it is superfluous drafting, you don't need to say the side yard sewer line has collapsed. All you need to say is seller shall replace the side yard sewer line. But in processing through that, where my head went was, what does it mean that seller shall replace the side yard sewer line other than that it has in fact collapsed? And speaking of sellers and listing brokers weaponizing this provision, my fear is that listing brokers are getting way ahead of themselves on this issue, and in counseling or advising a seller that the buyer has waived their their inspection contingency with drafting like that, and then we don't reach agreement as to what's going to be done. And seller then says, I own the earnest money, buyer, because you waived your inspection contingency, and now we go have a lawsuit over it with attorney fees at stake and everything else. Listing brokers, I have zero confidence that your seller is going to win that lawsuit. It's hard for me to imagine that a court is going to take $10,000 away from the buyer and give it to the seller because buyer's broker wrote side yard sewer line has collapsed, preceding the language, seller shall replace the side yard sewer line. Now, we're going to pick this up again because I have been persuaded by Ken and others in the industry, including some industry lawyers, that my statement might in itself might have gone too far. So we're going to back that up a little bit before the end of the video. But I want Ken to tell you what he said to me when I said, Well, what else could it mean other than that the side yard sewer line has collapsed if the buyer's asking for the side yard sewer line to be replaced?
Sure. So, and I explained to Annie that in parts of Spokane, some sewer lines were made out of a material called Orangeburg, which fails or is likely to fail. And so we have buyers asking for that sewer line to be replaced because it's Orangeburg, not because it has collapsed. I just don't want to have to deal with it 10 years from now if it does collapse.
Yeah. So that's a good point. I had other brokers say to me, well, now you're splitting hairs. You're saying that we can include this language, but we can't include other language. This is a portion of the inspection report, just like anything else is a portion of the inspection report. So there's the issue Ken raised.
And my other pushback was to start with the sewer line has collapsed. Goes back to what we've been talking about. What do you want the seller to do? The sewer line has collapsed. What do you want the seller to do? Replace the sewer line. So by putting in the information the sewer line has collapsed, I had an issue with that because now we're essentially putting seller on notice.
Right. Right. You're providing seller extraneous information. It's bad drafting. I'm going to conclude the same thing I did in my written question and answer, that it's bad drafting to say sewer line has collapsed because that's irrelevant to the contract, to the performance that we want seller to provide. So we've got that issue. We've also got brokers saying to me, how are we supposed to split the hairs that you're trying to split with your answer here that says that this language, this portion of the inspector's report is okay, but this portion isn't? And then on top of even that, I had industry lawyers say to me, Annie, you may be right. Seller may lose that lawsuit, but at least it's arguable. Buyer has at least got an argument to make if buyer-broker drafts the side yard sewer line has collapsed. And
The seller has the argument to make.
Seller has the argument to make that buyer has waived
buyer,
the inspection contingency. Thank you very much. And in this business, the last thing we want to do is create arguments, right? Your job as a broker, as Ken pointed out in a recent one of these videos, is you're held to the standard of care of a lawyer. That means that you're supposed to be creating contracts that avoid the argument.
Right.
Right?
Right.
So don't do it. There you go. There's the video title. There's the series title, right?
Don't do it.
Just don't do it. Don't include the language that says the side yard sewer line is collapsed. All you need to say for proper drafting and to avoid the argument is seller shall replace the side yard sewer line, because that's what we want them to do.
Stick to what you want the seller to do. That's it. That's it. I don't know how many times we can say it. I don't know how else to say it. What do you want the seller to do? Everything else, I like cake. Who cares? Fix it.
Is there anything we haven't covered yet?
I think we got it. I feel like we've covered it.
So one of the things that I mentioned in the history portion of the very first video series is that the risk to seller, and I just want to touch on this really quickly, the risk to seller of getting this information, the side yard sewer line has collapsed, for example. Seller may be a Spokane seller who says, yeah, I have Orangeburg line. I know that I do. I knew that I had it when I bought the place 2 years ago, but I scoped the line and it wasn't collapsed then, and we didn't think it was anywhere close to collapsing, and yeah, it might collapse in 10 years, but I have no knowledge that it's collapsed. And now you've said side yard sewer line has collapsed. I still don't think that's true, because I have a family of 8 and we flush the toilets many times a day and we've never had a single backup in the basement shower. So I don't believe it's really collapsed. But now that seller has this statement. Mm-hmm. What does seller have to do, assuming this sale fails, and now seller's marketing the property to another buyer, seller has this information from this Form 35R. What does seller have to do with that?
Well, I go back to the choices you said that a seller has, the 3 choices they have when something like that is said. And where I went immediately to my head was spend $100, $150 and scope the sewer line.
Yeah, because your choices are what? You can repair the problem. Now we know that there's a problem, so we can repair the problem. Or we can refute the problem, and that's where Ken was going. Now I'm going to have to take time before I can get the house back on the market. I'm going to have to spend money before I can get the house back on the market. Scoping the line is a lot less expensive than a lot of the problems that buyers raise. I might have to hire a structural engineer, for example, to confirm the stability of the structure, or a expert to confirm the stability of the hillside, or something like that. Could be a lot more expensive and a lot more time consuming, but that's what's involved in seller refuting, or seller has to disclose. And so now seller has to disclose a failed side yard sewer line that seller doesn't even themselves believe is a failed side yard sewer line if they don't want to spend the money refuting it, and they don't want to repair it because they don't think it's a problem. So that goes back, that ties us back into the first video of why the prohibition is included in the Form 35 in the first place. Just helps with a little bit of the understanding.
Sure.
Anything else?
No, you did drive home about listing agents overreacting and the risk in listing agents overreacting.
Yeah, so I'm sorry, but I didn't pick it up. I didn't close the circle, so thank you for that. The risk, listing brokers, is you're going to encourage your seller, you're going to practice law, because that's what you're doing. You're going to practice law by interpreting the contract and telling sellers that buyer waived the inspection contingency. Seller's going to run with that, and they're going to go fight for the earnest money in an interpleader action or through some other court process where the Form 21 says the prevailing party in that earnest money dispute will be entitled to recover not only the earnest money but legal fees as well. So listing brokers, if you're wrong, and I would say there's a lot of risk in listing brokers being wrong in some of the examples I've heard. For example, I've heard from countless buyer brokers a listing broker's conclusion that buyer has waived the inspection contingency by providing a contractor's bid. You're dead wrong on that. You advise the seller that the buyer has waived their inspection contingency, that seller should claim the earnest money. You have set your seller up for a losing lawsuit where they're not only going to lose the earnest money, but they're going to lose a lot of money in attorney fees. I'm not saying that every scenario is bad advice. You might give good legal counsel outside the authority of your licensing to give legal counsel and outside your insurance to give legal counsel. My point is, you're not licensed, you're not insured to give that legal counsel, and there is a huge risk that a court is not going to be nearly as strident in its enforcement of the language as you are, listing broker. So be very, very careful about assuring your seller that the buyer has waived their inspection contingency because the buyer broker has delivered what you consider a portion of the buyer's inspection report without seller's consent. I want you to be aware of the language, listing brokers. I want you to zealously enforce on your seller's behalf that prohibition, but I want you to stop short of giving your seller legal counsel outside the scope of your licensing and outside the scope of your insurance.
Yeah, our license, provide real estate services, fill in blanks on approved forms.
If you have questions on anything we've talked about in the last 5 videos or anything else, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.